She also gave you the. And then she gave you this setting the bottom.
She put up.
I'm sure it's not here, but that's, I don't know. She just came in.
Yes, it was probably time for a different voice. I'm not gonna get through. Yeah, she was retired one year. Okay.
All right, the separate session of the Hamilton County Common Pleas Court is now in session. The Honorable Wendy Crawford presiding. Please be seated, remain quiet, turn off and put away your cell phone. All right, good morning, everyone. Yeah.
Is this one on?
It's the mic. It's supposed to be.
It's not supposed to be on.
Oh, okay, it's not.
Okay, excellent. All right, here we go. That's better. All the levels are up too. All right, Mr. Prosecutor, what do you have for us first?
Sure. Mr. Perkins had a case.
All right, we can just do it from there. Mr. Perkins,
Good morning, Your Honor.
good morning. Name your case.
Osborne, David Osborne.
Oh, okay, so he needs to be brought down.
They did not bring him over today, but he has he also has a pending felony that has not been indicted yet. So that's likely to be coming through the court probably in the next few weeks. So it would be acceptable, probably make no sense just to set this for a day, perhaps early January. I'm going to be here on January 6th anyway. I don't know if that would work for the court.
All right, well, let me officially call the case. This is State of Ohio versus David Osborne, case numbers B2002477 and B2004318. Mr. Brian Perkins is present on behalf of Mr. Osborne. He was appointed yesterday. Thank you for accepting the appointment. And then Mr. Nick Croswell from the State of Ohio. Do you waive his presence?
Yes, Your Honor.
All right. Now, these are community control violations. Do you want a probable cause hearing to be scheduled?
No, Your Honor, we would waive probable cause, and everything is pretty much related to the new charges, so.
Okay. Mr. Prosecutor, do you know when that's going to be going to the grand jury?
I did not draw out, I was just informed this case about 5 minutes ago by the defense counsel. I'll have to look into what that charge is when it's scheduled.
It is it's a weapons under disability possession, I'm not sure what level, and improper handling of motor vehicle, except for a grand jury report on 12/17.
It's Friday.
Yeah, if there's an indictment, then it's gonna take another couple of weeks for it to work its way through here.
Yes, that's true. All right, so let's go ahead and continue this to the second week in January. Ms. Hopkins, if you can look for a date, second week in January, maybe?
Tuesday, January 11th at 9 a.m.
Would be good, Your Honor.
All right, perfect. Tuesday, January 11th 2022 at 9 a.m. Both matters, and we'll get that new charge if it proceeds to catch up. All right,
Thank you very much, Your Honor.
thank you. Do you waive time on these two cases?
Yeah, Your
All
Honor.
right, thank you. Oh, you know what, Mr. Perkins, I forgot. Because, we're doing stuff a little differently today, I have the entries here, if you wouldn't mind. At 9. Mr. Mundy, are you ready?
Yes, I am ready, but Mr. Costa is on code.
Oh, okay, well, then we can wait, yeah. Ms. Wolfenbarger?
Your Honor, my client is not here yet.
Okay,
Your
your client's not here.
I'm ready when he is.
You said he's not here?
He is not here yet.
Okay. Well, it's just 9 o'clock, so we give people, they might give them on.
I'll check the hall, I'll be ready.
Thank you.
You want me to call 48 minutes?
Yes, sir. Good morning, Mr. Adams. This is a matter of State of Ohio versus Brittany Hill, case number B2105580B. Mr. Jeff Adams on behalf of Ms. Hill, Mr. Nick Croswell for the State of Ohio. Mr. Adams, is your client here?
She is not. I spoke to her as recently as late last week.
Waiver presence
Waiver
today?
presence. What I wanted to do is see if she might qualify for diversion. I
Okay,
was going to walk her over there today to see if she is a qualified candidate for the diversion program. So I wanted to maybe we could set it for clear trial setting, even trial date. If the court wants to do that.
All right, let's see. This case is fairly new. It's 29 days old. Sure, if you'd like, we can go ahead and set a clear trial setting date, maybe 30 days.
That's fine.
All right, Ms. Hopkins, can you give that a 30-day date around the 14th, 15th?
Yeah. And this is a clear trial setting?
Yeah, the 14th would be a Friday, I don't know if the court does.
Oh, no, then, yeah.
So I could do the 13th or,
Yeah, the 13th, 9 AM.
that's fine.
All right, your trial setting continued to January 13th, 2022 at 9 a.m. You waive time?
Great contract.
All right, thank you very much.
Thank you.
We have an entry here for you. Yes, that'd be
You're on, Your Honor.
Yes,
Informally, they have to check in at 360 while we wait for Mr. Costa.
yes, Mr. Monday, thank you.
I'm not sure, Ms. Howard texted me, Mr. Costa, stuff there, but you know,
Oh, he is, okay,
yeah, so I'm not sure what his status is going to be.
okay.
Thank you, sir. You would file that, or you want to call that?
Yeah.
You're not going to walk out.
Do you, so the same thing that I don't know if you want to do
All right, counselors, what case?
Demetrius Stokes
Yes. All right.
was set for a final pre-trial, trial on the
10.
um,
Is he here?
He's in the Justice League.
All right, do you want him to come over?
I can get it.
All right,
He's upstairs.
I can't hear you.
I said, I think he might be upstairs. I'm waiting.
Okay. All right, so this matter is set for a final pre-trial conference. We have our trial date, which is in January.
Yes.
We won't have any more dates before then. Or is this on the path to go forward for trial?
I think so, Judge. As far as settlement, that sort of thing, I can talk to the Congress a little bit about that, but
Client counsel, can you speak a little bit? I'm sorry, I'm hard time hearing.
my voice is kind of shot. The main issue, I can talk to my client more about settlement. The main issue, however, is as I was going through everything, preparing it for the trial, what I came across is, I think, a motion issue, it's a question issue. And so I'd like to set as a hearing on the day of the trial as well, so that we continue to, that it's going to involve the detective, so he would be here anyways, I would think. So we do a motion maybe that morning, unless you want to do earlier in the case. I have this motion filed today.
You're going to file a motion to suppress?
Yes,
Why is it so late?
well, I just discovered the issue last week. It's what it is, Judge, is I believe that the false statement was made in an affidavit supporting the search warrant, and I just noticed the statement says going over everything.
All right. I will not set a motion to suppress hearing until a motion to suppress is actually filed.
Understood.
Then I give the state an opportunity to file a response if they desire to. It looks like January 10th is not going to be a good day for a trial. if we can do a motion to suppress.
Okay.
So this is what I propose. I propose to leave the date as is. When you file your motion to suppress, then the court will respond with the briefing schedule, and give the state time. Then I will vacate the trial date, and, we will handle the motion to suppress first, and then set a new trial if necessary.
Okay.
Is that how you wanna do it?
Well, that's, especially it's obviously what I do and how to set that. I'll try to talk to my client to see if he wants me to continue to pursue that. But it will be all resolved today. Whether or not I'll call the prosecutor and the comments and say.
Alright,
But as far as the vacating the trial, date and the briefing schedule, I mean, that's a complete interchangeable way of addressing it. So I don't have an issue with that. I just need to see, make sure my client is okay with it.
alright. Well, given that, today is December 14th, the trial is less than a month away. The motion to suppress is not filed yet, but you plan on filing it. I have to give the state an opportunity to give a response, and I usually give the state anywhere between 21 and 30 days. Given the holiday schedule, it's probably gonna be 30 days. So that's gonna take us past the trial date anyway.
Oh, I understand this.
Okay.
All I'm saying is I just want to talk to the client and see if he would say, well, I'd rather just do a trial than filing.
Okay, all right, well, then, let me go ahead and, so we really are not able to have a full final pretrial conference because you don't really know if we do that at this juncture, you may file a motion to suppress.
Yes.
Okay, all right, well, why don't we just leave everything as is, you talk to your client, and, we will hear from you by way of a written motion, or we will just be prepared. Now, if I don't get a written motion, then I will, and you want another final pretrial conference, just so the board know, okay?
I will, Judge.
All right, thank you very much. Time is way to January 10th already, but I have an entry here.
I would get it to him.
All right.
Oh, okay. You did it.
No, this is thank you. Mr. Trapp, good morning. Mr. Trapp, would you like to, for me to bring down Mr. Gabbard?
Yes, I've spoken with Mr. Gabbard.
Okay.
You did.
Probation violation.
Oh, okay. I'll see what she.
You have probably a probation violation.
I got that on.
Trying to read, community control and revoke a sentence. Yeah, yes. Thank you.
Yeah, I'll come over and let me do it.
Yes, sir.
Mr. Trapp, would you like to come up and, talk, chat about this briefly?
Which side are you?
So, Mr. Gabbard is on probation for just 6 months, and he's not done anything. He's in years. He hasn't further and there's like a video of the house and finished that. He probation hasn't seen him. They don't know what's going on. He hasn't told him his work. They don't know what's going on. They haven't done anything.
Pull him upstairs, he's got to take over one of the corners of the press. He says he got a letter and called in, and never got a response to that. Told me what it's on every day, once you get the letter. I don't think he understood it, but this dude is just as big as shit, but he has done some things. That's important, not important. But his employer here is very job, he's an answer, motors for a third day. He's an employer for his farm, so that's covered. They didn't let you go. He went on the phone to the cat house, but he got out of jail. Every 30 days, and he told me he's been working every day, he doesn't have. He's clean, he doesn't have issues, he's got people working, he's working. Never had a person. Well, and I told him that, you know, I understand teaching services, but,
What does he want to do today?
I'm gonna put him and ask you to terminate, because it's done 6 months ago, almost, so you can't do that, you're going on probation. He's got a job.
So you want to resolve it today? So you're going to talk to cause and
I will.
plead guilty?
Yes.
All right. All right. Thank you.
But he didn't have the probation.
Yeah.
Yeah, 90 right.
I didn't even look at that.
You ready?
Prosecutor, you have something ready?
Yeah, we'll be Griffin, Your Honor.
Okay,
Hallway, Judge.
all right, we're gonna have you come on in. That's it?
Just for a second.
I'm in the middle of two things right now. Yeah, I'm very sorry, we're multitasking because I don't have my bill.
Yeah, those are lots.
All right, hi, who's here?
This is just, James.
Hi. Nice to meet you.
Nice to meet you.
We got your paperwork, so.
Thank you, I appreciate you.
Not at all.
Thank you so much.
Have a good day.
Thank you, you too. All right, this is Mr. Griffin. All right, this is State of Ohio versus Isaiah Griffin, case number B2102136. Mr. Griffin is present in the courtroom. Come on, step on up, Mr. Griffin, with his attorney. Mr. Gustafson, and Mr. Nick Croswell for the state of Ohio. This matter is set for a final pretrial conference today. The jury trial is set for January 3rd, 2022. Counsel, is this matter proceeding to trial on that date?
As far as I know, Judge.
All right, so you will be prepared?
Yes, Your Honor.
All right. All right, so just want to quickly ask how many days you think it will take to try?
Well, I don't know how many witnesses the state of Texas. I mean, the sequence, Your Honor, is pretty quick. It's pretty simple set of facts. I don't see it going more than 2, maybe 3 days. That would be my guess.
All right, 2-3 days, all right, and Thursday being your selection. All right, I start exactly at 10:15 the latest on trial day, so the client needs to make sure he's here and ready. And then, I understand that, you know, there's a lot of hustle and bustle you do during the week. But I actually will shut the docket down and we will start, with my full attention to Mr. Griffin's case about 10:15. We take a mid-morning break, usually for 15-20 minutes. We go to the lunch hour, we take an hour lunch, and then we go full days, all right? I would ask that any motions in limine that you may think you may have, need to be filed the Friday before. And also, if you have any jury instructions, I ask that you put it in Word and send it to my staff attorney, Ms. Hopkins. Her email is on the court's website. Trying to think, I know you haven't had a jury trial with me, Mr. Crosswell has a couple of them already. I do allow the jury members to take notes, but not ask questions. I'm pretty formal, so I would just ask that no speaking objections, just objection, and you give your grounds. I think that's pretty much it. I'll have the charge conference for the jury instructions after the presentation of the evidence. I usually try to do it like maybe at the end of a lunch break, and give the jurors a long lunch break, but we fit it in wherever we can, so. Is there any questions you have, Mr. Gustafson?
Mayor, I did file a motion for you this morning,
I see.
and I apologize, I made a mistake. For some reason, I had in my mind that this incident occurred at Main and 8th. It actually occurred at Main and 9th, which is a lot closer to the courthouse. So it's just right here, about a block and a half from the courthouse is where the incident would be. What we'd be requesting the jury to do is the view looking to the west from the east side of Main Street, looking west on 8th. That was the direction of travel of my client. The allegation is they attempted to run somebody over at the crosswalk on the west side of Main Street, crossing over 9th. So, we want
And
to.
photographs or video is not sufficient?
Well, Judge, there's a bunch of objects lining the sidewalk on either side. So, looking at some of the body camera videos, there's some statements that are alleged. I think to understand whether or not what the witnesses are alleging is possible, the jury needs to have a full understanding of what objects are there in the area. So that's the reason for it.
Let me ask this, approximately when did this alleged incident occur?
I believe June of this year, Judge.
June of this year. So I know there's a lot of construction down here right now, so I'm wondering, just wondering for your consideration, if the scene is the same.
I believe it is, Judge. I pass by there on a regular basis, so the pertinent items that we think are relevant to the inquiry, there's a tree there on the north side of 9th Street. There's a mailbox, which is the U.S. Postal Box, that's been there for years. There are various poles for either utilities, walk lights, stop lights on either side of the street. So all those things are permanent fixtures. The tree, while somewhat youthful, has been there for years. So I haven't observed any changes, and I don't know that there's any construction that's been done at that particular intersection and location where it occurred.
All right. State. All right. Well, I will take this under advisement, and we will make that decision close to the trial. And we have to make sure that the scene is absolutely the same when, if it were to happen. So I would thank you for this, and I will take that under advisement. And so we'll go ahead and proceed for January 3rd at that time at 10 a.m. Unless there's anything else, council?
No, we have to-
All right, thank you very much. We'll see you then. Yes, and let me have your client sign it too. Wait time, January, just wait time. All right, if your client's here, do you mind if your client sign? Thank you. All right, this is the matter of State of Ohio versus Leon Gabbard, case number B 2005607. Mr. Gabbard is present in the courtroom with his attorney, Mr. Michael Traft. You come to the podium, sir. and Mr. Nick Croswell for the state of Ohio. We're here for a post-conviction warrant return probation violation. Does the defendant wish to have a probable cause hearing, Mr. Trev?
No, Your Honor, we waive probable cause, that's the,
All right, Mr. Gabbard, is that what you want to do today, is enter a guilty plea to the probation violation?
Yes, ma'am.
All right, and you are in agreement with waiving, not having a probable cause hearing?
Yes, ma'am.
All right. All right, do you have a copy of the factual basis?
I looked at it, Your Honor.
All right, may I have a factual basis of the violation put on the record?
Your Honor, on probation through this court, to my understanding, he violated rule number 5, in which he failed to provide proof of employment to probation. Rule number 8, he failed to report via telephone on July 12th as directed in his interview. He also missed 2 appointments, or excuse me, 2 appointments as well. Rule number 10, he also violated, he failed to make payments by route that has been taken care of at this point.
All right, thank you. Anything else on the facts, Mr. Track?
we don't contest the facts, we do have some disagreement about the reporting, but we'll admit that we violated our probation.
All right, based on that admission, is that correct, Mr. Gabbard?
Yes, ma'am.
All right, based on that admission, the court finds you guilty of the charge of violating the terms of community control. Is there anything further from counsel in mitigation?
Yes, Judge, thank you. Mr. Gabbard is 42 years old, he grew up in Harrison High School, he graduated from East Central High School. He's worked most of his life as an auto mechanic. He's got 2 children who are with him, and he's 13 and 18. He's never been to prison. His employer, Mark Lodge, is here. He runs Milestone Motors. Mr. Gabbard is employed here. Mr. Roddy paid off with these costs yesterday in the amount of $649. He wants Mr. Gabbard to be out because he's got a lot of work for him. I don't know why probation wasn't informed of this. I don't know if there's a mix-up or whatever. But Mr. Gabbard, after he got out of this courtroom, he went and voluntarily put himself in the cat house for 30 days. Successfully completed that. Then it was on. And I guess he didn't take his reporting duties as seriously as he should. He did tell me that he went to probation on July 12th, and that's how he knew it was a probation. I think he did that. And he said he got one of these 2 letters, and one of the letters he called him once, never heard back. So he kind of stopped, and I told him that was a mistake, and he's got to be more, he's a little aggressive, take the whole burden on him, and he's going to have to call his probation officer every day, because this is what happens to you. Judge, he's never been to prison. He tells me he doesn't have a problem now. I can't house open. It was a blessing for him. He's got a job that wants him out. I would ask you to either terminate him or at least keep him on probation. But not the violation.
All right, thank you very much, State.
For deferred.
All right, anything you'd like to say, Mr. Gabbard?
Yes, ma'am. I just want to apologize to the court and you. I guess I didn't take the full responsibility of calling every day. I know it's no excuse. I just had a lot of things going on with my children. We were sick. My daughter was sick. My mom had surgery. And I just got a second job just to try to help pay for things. And I'm so sorry, Your Honor. I did not mean to be standing here in front of you today doing this. I apologize for everything. I did not try to hide from no one. I try not to do nothing, try not to break no laws, do nothing, Your Honor. I apologize more than anything.
All right, thank you. Well, obviously you've been working, your employer's here, and even paid your fees and costs off, which is a good thing. One of the pieces of the violation was that you didn't provide proof of employment, but obviously you've been working. But you can't provide that if you're not reporting. I only put you on for 6 months. And so, all right. Well, what I'm going to do is I'm going to, add an additional 6 months. But I will be open to terminating early if you dot all the i's and cross all the t's. All right, so that means report. I know you successfully completed the cat house, and your probation officer said you did report on July 12th, but since July 12th, he hasn't seen you, or heard from you. And so, there's gonna be an additional 6 months community control, cost remit, since you paid off everything, I'm not gonna add anything to that. If you violate this next time, you will go to prison. And the range is between 6 and 12 months. It's not worth it. All right? All right, so, that will be the judgment of the court. So an additional 6 months to complete probation. All right, that means report, because that's really the only piece of it that you haven't done. You've done everything else.
Yes, ma'am.
Just report. And, if I get a good report from your probation officer that you've been doing as you need to do, then, I will consider terminating earlier than 6 months. All right, you have a right to appeal your conviction and sentence. Should you choose to do so, you must do so within 30 days. If you cannot afford to process your appeal, an attorney will be appointed at no cost to you to help you. Do you understand?
Yes, ma'am.
All right, I wish you well. You'll be released today.
Thank you, ma'am. Thank you.
You gotta go to probation as soon as you get out.
Okay, yes, sir.
Okay?
Yeah, all right, thank you.
Ms. Walkenberger, your client?
He is, Your Honor. I came at 9, but it's actually set at 9:30.
I'm sorry.
I came here at 9, so it was actually set at 9:30, so I was just.
Oh, you were early.
We're ready when you are.
Okay. Thank you. All right, so are you ready for us to call Mr. Williams down? Mr. Walker?
Yeah, I can call him down too. Yes.
Yes, Mr. Williams. Come down. Okay. Who else can we do while we're doing that?
Good morning, Your Honor.
Good morning.
Does everybody want to do
Sure, sure.
Yeah. Yeah.
Mr. Harris, are you ready on yours?
We are, Your Honor.
Okay, it's a clear trial setting, right?
It's a plea
Oh,
trial.
it's gonna be a plea?
Yes, ma'am.
Oh, I see, okay, I have someone come down.
I'm ready, I'm off, easier.
When you get, you be on the Demetrius beds.
Yep, let's do that.
Oh, I'm sorry.
Justice Sullivan. Okay.
Good morning, Your Honor.
Good morning, this is the matter of State of Ohio versus Demetrius Betts. Case numbers 210-4560 and 210-4652. Ms. Danielle Colliver for the state of, for Mr. Betts, and Jeff Croswell for the state of Ohio. Ms. Colliver, do you want your client to be brought down?
No, I can waive his appearance if the court will allow.
Yes. How would you like to proceed?
Your Honor, I'm going to ask for another date. The prosecutor has indicated he sent the MDR video, although I don't have it in my email. So he is going to resend that, and then we are still waiting on the body worn camera, as well. So I'm just going to see the new date on wait for discovery.
All right, let's see. All right, well, we have plenty of time on these matters, and we already have trial dates.
Right.
And, all right, so first week in January, would that work for you?
Your Honor, that week is actually getting a little crazy. Is it possible to go into the second week?
Sure. Ms. Hopkins, second week in January.
Can do January 11th at 9:30 a.m.
Perfect.
We have an entry, so we have the entry.
I do, Your Honor.
Still an outstanding discovery.
Thank you,
Will
Your
you be
Honor.
seeing your client today?
I'm sorry.
Will you be seeing your client today?
Actually, I am going to go up to see him.
All right, excellent. I was just want to give you these waivers here on these, both these cases, if you could fill them out and your client sign them. Thank you so much. And you might bring them back and put it this way.
Absolutely.
Thank you.
Thank you, Your Honor.
Morning, Judge.
Good morning.
Mr. Clark's on a juvenile Zoom hearing, so he's right outside the
Oh,
meeting.
okay. All right, thank you.
I'm gonna be on last and she's bringing away.
Ms. McCluskey, are you ready?
Sure, Judge.
Okay. And you are Mr. Blevins, right?
Correct.
All right. City of Ohio versus Robert Blevins, case numbers B2103952A and B2105278. These matters are set for a clear trial setting, and we have a trial date that is set on January 24th, 2022, correct?
Correct.
And I believe we advanced that because the defendant is not waiting time.
Correct.
All right, and so, is it, are you on track for trial? All right, what I'll do is I'm gonna set a final pre-trial conference on January 13th at 9, January 13th at 9 for a final pre-trial conference. Does that work for you, Mr. McCluskey?
It does, Your Honor.
All right, thank you. January 13th at 9 a.m. for a final pretrial conference on Mr. Blevins' cases. Mr. McCluskey, do you waive his presence for today?
I do, Judge.
All right, and I'm happy to have him brought down for the final pretrial conference so we can discuss trial. All right, thank you very much. Ms. Wolfenbarger, do you know if Mr. Nye is going to be here for the other case? He has one case with Mr. Nye and two with you.
I assume that he will be here, but I have not seen him yet.
Okay. Well, I don't want to call him back down for Mr. Nye, so I want to see if Mr. Croswell, do you happen to have Mr. Nye's contact information?
No.
Okay.
He's in the building.
That's still on?
He has his cell phone here.
I've got it.
Oh, thank you.
He did,
His client is down and he and his local barber share his client, and
Ms. Howard did tell me he is a roommate.
he's
So
a,
there's 800 in the bag, so we don't.
Mr. Nana? Oh, wow.
I can argue his bond that he has so the new case was set for a DSC. I filed a motion for bond on the fees. You want to do that?
We did, and also Mr. Nye did a written plea of not guilty by reason of insanity, so I'm just gonna sit for court evaluation. That's it. Can you handle it?
I can, okay.
All right, well, let's do that. Thank you.
Sure.
All right, these are the matters of State of Ohio versus, is it Dontarius? Dontarius Williams, case number B 200-6170, B 210-0466, and B 210-5833. Mr. Williams is present in court with his attorney, Ms. Stephanie Wolfenbarger. And Ms. Wolfenbarger is standing in for Mr. Gary Nye on case number 5833. Is that accurate, counsel?
Yes, ma'am.
And then Mr. Dick Croswell is also present for the state of Ohio. These matters are, two of the matters are set for trial setting, and the case that Mr. Nye handles, case ending in 5833, is set for DSC. Let's start with your cases, Ms. Wolfenbarger.
Your Honor, I have two probation violations. I did represent him on those original cases. And I give you a copy of it. I filed a motion to set bond on those.
You did.
And he does have a bond on the new felonies. However, there is no bond on his probation violations. Because a portion of the basis of the violation is the new charge, I believe it's in his best interest to resolve the probation violation together with the new felony. However, he doesn't have a bond on his probation violation. We're asking today that he set a bond. Yes, to bond. Mr. Williams has some significant untreated mental health issues that were not brought to my attention. I believe some of them have arisen out of new, can you hear me okay?
Just a little louder.
Some of these issues have arisen out of things or become more severe out of things related to things that have happened since he was sentenced by you. His father passed away recently, and he's had 3 or 4 friends pass away. He spent some time just before he was arrested on the new charges in Glenwood Behavioral. He was there for about 2 weeks because of his mental health issues. He was working with GCB before he was locked up, and he was also working at McDonald's and Waiver. He's been diagnosed with bipolar, PTSD, and schizophrenia. If a bond were set and he's able to get out, he would be able to continue working with his GCP worker and treating his mental health. And generally, in my experience, the jail does not quite handle those things as well as they need to be. And his mother is in the courtroom as well today, supporting him, and she was
Mom? Thank you.
always present during his other case as well.
All right, thank you very much. So he lives with his mom?
Yes,
All right. And is he prescribed medication?
yes.
Does he take his medication? All right. All right, state.
You know, I apologize, if this is the first time up, I don't have the file for this. Would you tell me what the bond is on the new charge?
Yes, so the new charge, which is having weapons while under disability, felony in 3rd degree, room A set the bond at 2,500 at 10%. Is that accurate? That's what I saw. All right. There were 2 charges. One was ignored because it was $1,000 on the other charge and 2,500 at 10% on this charge. But the other charge was ignored.
Correct.
And so you were asking that I set bond on these probation violations?
That's correct.
Yes. All right.
You know, given the fact that he had previous weapon charges, is on probation for that, and picked up new charges, I do have concerns for the safety of the community, but ask for a, you said bond, as a higher bond.
All right. Well, I am while I'm considering the bond issue, there is a motion, well, there's a written plea of not guilty by reason of insanity, and I'm going to get a request for evaluation of his current competency. And so I'm going to do a court clinic evaluation on case ending in 5833, continue this matter for 30 days for that evaluation to occur. And so let's go ahead and set these matters first, and then I'll talk about the bond. So we need about 30 days, Ms. Hopkins.
About January 13th, at 9:30 a.m.
That's fine.
January 13th,
They're on both cases, Your Honor.
it's gonna be on all three. The new case and the two probation violations. January 13th. At 9:30, sir?
Yes.
Okay. It's time late.
Yes,
All right, thank you. We have some entries for you to sign in just a moment. All right, I too am concerned about the new charge, but I do recognize it is just a charge. And Mr. Williams stands innocent unless proven guilty, beyond reasonable doubt, but I am concerned about the new charge. I'm gonna set the bond at, $7,500 at 10%.
Alright, so total for both cases. Those are probation violations.
Yeah, they're both the same probation violation, so, yes. 7,500 at 10%.
Thank you.
All right, and so, we will see you back here, Mr. Williams, on January 13th, 9:30. And, you will talk to, well, Mr. Nye has to, talk to you about, getting your court clinic evaluation. You understand? All right, so, either Mr. Nye will come and see you at the Justice Center, or upon your release, you will need to contact Mr. Nye immediately so you can get this court clinic evaluation taken care of before you come back. You understand? All right. Anything else, Ms. Lichtenberg?
No, Your
All
Honor.
right, thank you.
What are you gonna do here? You gonna keep going around? Now I got out of the room to go see that issue now. Taking care of 360.
Ms. Lichtenberg, I think I can set up on each one. So then we'll set it on the one. 10%.
Yeah, I guess you have to extend.
That's it.
I got it from.
One's already has that.
I'll say it.
Yes. The one has a bond on it, it's case number 5833.
So it's 12:15.
plus, other money.
So it's total 15 and 10% for the two. And then, yeah.
We approach on Roger, you should be heard.
Yes.
Good, that's it. Good.
Mr. Mundy,
Yeah. One second.
we were set for trial, Your Honor, beginning of the year. Mr. Mundy filed a continuance on that.
Oh, yes.
We anticipated it happening.
Yes, and that is because you said you would let me know what the hearing date.
Judge, we're looking for this video. Talk to my client, Saturday, take the disclosure, the hearing on the available. He was anxious to get the hearing, he says that is what was on there. Report that states that maybe some portion of it may be captured on body camera.
This occurred in marriage, Dr. Howard. He assaulted one of the employees. It was captured on the video. The owner wasn't able to really work for a period of time. On the captured body camera, you can see the struggle. She actually pulled up on her cell phone, which was part of it viewed on body camera. This is the money where which the read that on. You can see part of it, not all of it. But my understanding is after that, officers attempted to get a hold of that video, and in the process of that, the owner's subscription time look back lapsed, or like a 30-day look back. So it was never able to be successfully given to law enforcement. But there is a portion of it which you can see, but not all.
It sounds like it might be administered by a third party.
If we, I also was gonna double check with the victim, the owner, probably still and get back to me, he has not done so at the last ditch effort. I don't know if who the security system, like Ring or whoever it is, I don't know. Going up that level.
All right, well, we do have to time this matter, this matter was set on trial.
You want to subpoena that code.
I will grant, any objection to this, I will grant your motion for continuance, and, my potential dates are January, February 14th, 14th.
Yeah, grab my phone.
Did you talk to Austin on this about, is it going to continue? So we're gonna make it the first, everybody,
And it says, Edward Street, we're part of 170. And Your Honor, you said 14. He is in the hall, would you like him to come? You go behind him.
All right, so.
I'll bring him in.
State of Ohio versus Ricardo Henderson. Case number B 2103104A.
He's approaching, Judge.
All right. Mr. Ricardo Henderson is present in court with his attorney, Mr. Bernard Mundy, Mr. Nick Croswell for the state of Ohio. Good morning, sir. This is set for a final pretrial conference, actually. It was supposed to be for a final pretrial conference. The trial date being January 3rd, 2022. I have a written motion for continuance filed by Mr. Mundy. There's no objection by the state. Is that accurate?
Correct.
All right, for good cause, I'm going to go ahead and grant a motion for continuance of the trial date. Mr. Mundy, I have two potential dates, February 14th or February 28th.
Your Honor, we selected the 20th of February of 2022 at 10 a.m.
All right, so the trial date will be continued to February 28th, 2022 at 10 a.m. Wait time,
So waiting, Your Honor. Thank you.
and I do have an entry for you, and then Mr. Mundy, I have a waiver of speedy trial here. You might need that too, but, you had a client execute that, explain it to him, and have him execute.
All entries have been executed, Your Honor.
All right, thank you very much.
Thank you.
All right, have a great day.
You too.
Judge, Mr. Clark, can I approach on Jamal Morris?
Yes.
Nice job on your carpet.
Thank you.
I was gonna say that, he said,
Okay.
That's real, that's really good too. Yeah, really good.
See, he didn't notice that.
Judge, when I'm in here, you're the focus. I'm looking at it.
Oh, you know what, he just knows what to say.
Exactly.
He just knows what to say.
On Jamal,
You gonna go there?
No.
Okay.
I'm gonna go and see. We're on for a basic, when you return, you need mental health records.
Yeah.
We can send out some, my expert report, we've got over 4,000 pages. You got them last week. What I'd like to do is set it for, not set it, maybe in the middle of the year, with the holidays and stuff, I'm hoping that will give her plenty of time to go through, there. And in the meantime, I'm trying to build up a relationship with him, so I can get him to cooperate with him. If that's okay with you.
That's, we have, a tentative trial date for March anyway, so let's go ahead and set, Mr. Jamal Morris for another, let's set him for clear trial setting in 30 days, mid or so, January.
Is there a day that you do those, or?
Just leave it now.
Is there time, you know, that's what
I mean, there's gonna be so many trials that we can always stop by.
Okay.
I'm not worried about it.
What about Tuesday, the 11th, I'm picking that.
It's Tuesday, January 11th, with Ms. Hopkins.
Yes. Like 9 a.m.
Yes, ma'am.
All right, clear trial setting, Tuesday, January 11th, 9 a.m. Time wave.
Yes, ma'am. Just so the court's aware, that trial date that he had, check. I'm almost certain I can't keep it. Because I have older case that was set. Before that, on that same day.
Okay, why don't we,
Yeah, but I just wanted to let you know.
can we address it in January?
Yeah, I didn't say, I just want to give you a heads up.
I appreciate it.
But we don't have to do it now.
Okay, we'll do it.
My name,
Yeah.
Seth.
Yes.
I'm adding for the region defense expert doing mental health record.
Cool.
Thank you so much.
All right, thank you.
Jay, I hate to admit this, but you and I, our calendars, we have the same black page, same calendar.
Let me make you feel better. Pete Rosenwald.
Okay.
Say you passed.
Yeah, I think I've said it for free.
Pete, you know what's funny?
Sorry, I was gonna
I
say
said, he had all of his from the day he started practicing.
Did you hear what was going on?
Yeah, that makes sense.
See, everybody's good?
Everybody.
Like it's under
Thank you
one.
so much.
Thank you.
Yeah, you did one.
Alright.
He used to be blue.
I don't think everyone put it down, so we want to do Mr. Harris's case.
We have a bird waiting all morning.
Oh.
Just on that.
Sean
Just
Ross.
on This is gonna take me.
I'll let you
She's fully vaccinated
Okay,
and she just feels like she's a cold.
okay.
So, yeah, thank you. So she'll be back next week. Thank you so much. I'll tell you this.
I did not.
Sean Ross.
Yes, thank you.
Section 17 on a entitled discussion of federal court.
All right, thank you. All right, this is a matter of State of Ohio versus Sean Ross, case number B2103412. Mr. Ross is present in the courtroom with his attorney, Ms. Stephanie Wolfbarger, and Mr. Nick Croswell for the State of Ohio. This matter is set for sentencing today. Mr. Ross having entered a guilty plea on November 17th, 2021 to count one, possession of fentanyl-related compound, a felony in the 5th degree. The court ordered a pre-sentence investigation report, and I'll ask counsel, have you had an opportunity to review it?
I have not.
All right,
I have not shown
All right.
it.
let's see. John, do you have the, oh, he has it. All right, I'll give the state just a few minutes to.
You go.
Okay.
I'll be done.
All right. Ms. Wolfenbarger, is there anything you'd like to say on behalf of Mr. Ross?
Yes, Your Honor. He does have a little bit of a record, however, his last felony was in 2014. I believe that's indicated in the PSI. He is working at Family Dollar in Covington. He indicates to me that this was a relapse. He has been sober for a couple of years now, and this was just a relapse. He is currently going to the methadone clinic daily. He's attending weekly substance abuse counseling at UC Addiction Sciences. Since his last felony, he's not having any additional felonies outside this. We would ask that you place him on term of probation. And also, we did file a affidavit of indigency at the plea hearing. We would ask that you waive any fines or costs and forego the license suspension. He is already suspended, and an additional suspension would make it more difficult for him to clear up those issues.
All right. I do have your original request to waive the affidavit of indigency, but you said he's working.
Part-time.
Oh, part-time.
20 hours a week sometimes.
How long?
20 hours a week sometimes, like 16 hours a week, depending on where the truck comes in, help them unload the truck. So
I see.
it's like 3 times a week,
All right,
6 hours.
all right. Thank you. Steve?
Your Honor, looks like he did have a drug possession in Kentucky in 2020. That the most recent kind of relative thing I see. Probation is recommending, or rather, the PSI indicates recommendation of either enhanced supervision or placement for drug programming. I was okay with enhanced supervision. That would work.
All right, thank you very much. Mr. Ross, is there anything you'd like to say, sir?
Yeah, I'm already, treatment, like I said, I'm on UC, I'm weekly with my counselor. Yeah, I've been on the same dosage, I ain't try to increase or anything like that, I'm just taking enough to where it just keeps me from having to use. Yeah, so like I said, I go to weekly treatment already, and I ended up messing up with it, so I already see treatment for this, you know what I mean, like, soon as I realize I do that. If you want every day, I can call up there, I'll talk to you, council. OW, we see signs, we see signs, oh, yeah, it's like, or, the guy, certain,
All right. I'm sorry, what else did you say?
You just asked that you take that into consideration.
yeah, I didn't hear about there, so.
Absolutely. All right, well, I looked at your statement, and you indicated you were in a program right now, a methadone program, you relapsed and just kind of slipped. But what was really stuck out to me was you said, I got pulled over. Can we have her step out for just a moment? I'm sorry. Yes, the court reporter hears everything, so she's trying to listen to me, but she can also hear the little one too. Sorry. What stuck out to me, sir, was you said I got pulled over before I even had a chance to use. I'm glad you got pulled over before you had a chance to use. Because that dose could have killed you. And you could have not been here. So there's a reason why. Absolutely. And so count your blessings, because you could not be here. I'm glad that you.
Well, I still 14 years old, but I still like it.
I'm glad that you are going to your program and still working your program. I understand that this is a process. Addiction is a process. So, all right. Having considered the overriding purposes of felony sentencing, punishment of offenders, and protection of the public from future crime using the minimum sanctions that accomplish these purposes without imposing an unnecessary burden on state or local government resources, and having considered incapacitation, deterrence, rehabilitation, and restitution to achieve these purposes in accordance with the Ohio Revised Code, Section 2929.11, I hereby sentence you, sir, to a term of 1 year of community control, intensive supervision. I will remit the costs and fines and sign your affidavit of indigency. I will let you know, sir, that if you violate the terms of community control, I have at my disposal a range of between 6 and 12 months, and I will send you to the Ohio Department of Corrections. Do you understand?
Appreciate it. I'm taking serious.
All right, the state has submitted an entry of dismissal of count 2, which I've already signed. I want you to know that you have a right to appeal your conviction and sentence. Should you choose to do so, sir, you must do so within 30 days. If you cannot afford to process the appeal, then an attorney will be appointed at no cost to you to help you. Do you understand? All right. I wish you well. Work your program, report to probation. Ms. Wolfenbarger, will you explain that to him?
Yes.
Thank you very much. I wish you well.
Morning, Judge.
Good morning. How are you doing?
Doing well, how are you?
Good. We're doing a lot of multitasking today, so. But, you gonna stick with us the rest of the morning?
Mr. Croswell had a case that he had to take care of, and so I'd imagine he'll be back.
Okay, all right. Thank you for being here.
I think we can.
So,
Ryan, what's yours?
all right.
Mr. Mayor.
Mine is David.
No, we're gonna do this. Here's the slide.
Okay.
So, Mr. Harris, if you and your client would mind coming to the podium. Mr. Magnus, do you have a plea or trial setting?
I do, Your Honor.
All right. Can I do your plea or trial setting real quick? I just want them to be here because I want them to know their rights. All right. This is the matter of State of Ohio versus Fancy James Maiden. Did I pronounce that right?
Yes, ma'am.
All right. Case number B2104120B. Mr. Maiden is present in the courtroom with his attorney, Mr. Rodney Harris, and Ms. Colson for the State of Ohio. This matter was set for a plea or trial setting, but it's my understanding, after having been provided written plea forms, that this matter is being resolved by way of a plea. Is that accurate, Mr. Harris?
That is correct, Judge. In exchange for Mr. Major's plea of guilty to count one, the state is willing to dismiss count two.
All right. Is that your understanding, Mr. Maiden?
Yes, ma'am.
All right. Are you the Fancy James Maiden named in this indictment?
Yes, ma'am.
How old are you? 20?
Yes, ma'am.
Okay. How far did you go in school, Mr. Maiden?
I got my high school diploma.
All right. So you're able to read and write the English language well?
Yes, ma'am.
All right. I know it's a odd question, but there are lots of people who can't. So I just wanted to be sure. Okay. All right. Have you ever served in the military? Are you a U.S. citizen?
Yes, ma'am.
Okay. Mr. Maiden, I have two forms, one entitled Waiver of Trial by Jury. It's a single-page document. There are signatures at the bottom. I recognize Mr. Harris's signature here, but is this your signature here where it says defendant?
Yes, ma'am.
This is an acknowledgement by you that you understand that you have a constitutional right to have a trial. But when you sign this form, you're saying, I understand that, but I'm giving it up. I'm waiving my right to a trial. Is that your understanding of what you were doing when you signed this form?
Yes, ma'am.
Did you sign this form after you spoke with your lawyer about your constitutional right to have a trial?
Yes, ma'am.
Do you have any questions about this form? Do you have any questions about your constitutional right to a trial? All right. I also have in my hand, Mr. Maiden, a 3-page document entitled Entry Withdrawing Plea of Not Guilty and Entering a Plea of Guilty. On the 3rd page, there are signatures. I recognize the prosecutor's signature here, your attorney's signature here, but right here, is that your signature?
Yes, ma'am.
All right. Madam Prosecutor, would you please put on the record the parties' agreement regarding this case?
Judge, it is my expectation that the defendant will plead guilty as charged to count 1, move to dismiss count 2.
All right, and that's what your attorney said earlier. Is that your understanding?
Yes, ma'am.
Okay. Are you under the influence of any medications, alcohol, or drugs today? Have you ever been diagnosed with or even suffered with any type of mental health difficulties? Are you presently under any type of probation or community control supervision? Has anyone threatened, forced, or coerced you in any manner into entering into this plea of guilty today? Has anyone promised you anything at all if you enter into this plea of guilty today other than the dismissal of count 2? Are you making this plea of your own free will?
Yes, ma'am.
All right, so the state has indicated, Mr. Maiden, that you're willing to enter a plea of guilty to count 1, aggravated trafficking in drugs, with a dismissal of count 2, which is aggravated possession of drugs. So the one is aggravated trafficking is what you're pleading to. The aggravated possession would be dismissed. Do you understand? Is that what you talked with Mr. Harris about before this hearing today? Did Mr. Harris answer all of your questions about it? All right. Do you understand, have you had a chance to read or review this 3-page plea form with your lawyer? And do you understand what it says? Do you have any questions right now? Mr. Maben, do you feel like you've had enough time to consult with Mr. Harris about your case, your entire case, before today? Has he answered all of your questions to your satisfaction? Have you had an opportunity to review the evidence, whether you saw it with your eyes or discussed it with your lawyer, the evidence the state has against you? All right, Ms. Prosecutor, would you please put on the record whether or not the state has provided all discovery evidence to the defense, including any Brady material with it, to your knowledge?
Yes, Judge, my knowledge of discovery has been provided to me.
All right, Mr. Harris, do you acknowledge you see the same?
We do, Your Honor.
All right. Mr. Maben, are you satisfied with your attorney, Mr. Harris?
Yes, ma'am.
Now, do you understand the charge against you? Aggravated trafficking in drugs in count 1, a felony of the 4th degree.
Yes, ma'am.
Do you understand that if you plead guilty to this offense, you are making a complete admission that you committed the allegations contained in that count of the indictment?
Yes, ma'am.
Do you understand that if you plead guilty, the court may enter a judgment of guilt against you and proceed to sentence you immediately?
Yes, ma'am.
Now, this being a felony of the 4th degree, do you understand that you are facing a potential sentence of between 6 and 18 months?
Yes, ma'am.
And do you understand that you are facing up to a maximum fine of up to $5,000?
Yes,
Now, do you understand, Mr. Maben, that if I sentence you to prison, upon your release from prison, you could be on post-release control for up to 2 years? Do you understand?
ma'am.
All right. And Mr. Harris, you filled this out correctly. Would you mind in this last column just putting up to 2 years?
Yes, ma'am.
Thank you. Thank you.
Yes, ma'am.
Judge, you did a district deal,
All right, thank you so much. If you violate the conditions of post-release control, that's if you were to go to prison, and if you were released on post-release control, and if you violated the conditions of post-release control, you could be returned to the institution for a total of up to 1/2 of your original sentence. Do you understand?
Yes, ma'am.
Are you on post-release control? All right. Well, do you understand that if you are on post-release control and you are convicted of a new felony offense while on post-release control, that in addition to being punished for the new felony offense, the sentencing court could add an additional consecutive 1-year prison term or whatever time remains of your post-release control time, or whichever is greater. Do you understand? All right. Since this is a felony of the 4th degree, Mr. Maben, community control is a possibility. Do you understand that I could place you on community control instead of sending you to prison for up to 5 years? Do you understand that if you are placed on a community control sentence, you will have to abide by all probationary conditions as established by this court? And if I place you on community control and you violate the conditions of community control, you will be brought back before me for a more restrictive sanction, which could include a number of things, but also could include the imposition of prison time up to 18 months. Do you understand? Also, if I impose court costs and you fail to pay the court costs, I could order you to complete community service instead of paying court costs. Do you understand? Do you have any questions at this time, Mr. Maven? All right. When you enter a plea of guilty, you give up some very important constitutional rights that I need to make sure that you understand. Do you understand that you have a constitutional right to have a trial, either to the court or to a jury of 12 persons? Do you understand that you have a right to confront witnesses here in open court and have them cross-examined by your lawyer? Do you understand that you have a right to have witnesses subpoenaed to come to court and testify on your behalf? Do you understand that at trial, it's the obligation of the state of Ohio to prove your guilt beyond a reasonable doubt? Do you understand that you cannot be forced to testify against yourself at trial? Mr. Maiden, do you understand each of these rights as I explained them? Do you have any questions whatsoever about your constitutional rights? Do you understand that if you plead guilty, you are waiving or giving up all of these important constitutional rights? Knowing everything that the court has discussed with you this morning, do you still wish to enter a guilty plea to count 1, aggravated trafficking in drugs, a felony of the 4th degree? All right. Is there anything further from counsel before I accept the plea?
Nothing at the time.
All right. May I hear a statement of facts?
Honoring about August 10th, 2021, Hamilton County, Ohio. Defendant did knowingly prepare for shipment, shipped, transported, delivered, prepared for distribution, or distributed a hitherto controlled substance, oxycodone. At the same time, he knew and had reasonable cause to believe the controlled substance was intended for sale or resale. Your Honor, specifically, this all occurred under federal officers doing hand-to-hand transactions coming from the vehicle. Different officers made contact with that vehicle. 28 oxycodone, Percocet pills found in the pants of the defendant.
All right.
So let's see John on the person.
All right.
Nothing on the
Thank you. Mr. Maiden, did you hear the prosecutor say you did?
Yes, sir.
Is it true?
The mouse is taken on the street.
I'm sorry.
Is it true?
Is it true?
No, I was just taken on the street. It is true. I'm sorry, when I say it's true.
All right. Well, let the record reflect that Mr. Maiden was present in court with his attorney, Mr. Rodney Harris, and that Mr. Maiden was informed of all of his constitutional rights and has made a knowing, intelligent, and voluntary waiver of those rights. The court finds that Mr. Maiden understands the nature of the charge, the effect of the plea, as well as the maximum penalty which can be imposed. Finding it to be voluntary, the court accepts your guilty plea and finds Fancy James Maiden guilty as to count 1, aggravated trafficking in drugs, a felony of the 4th degree. In violation of Revised Code 2925.03, subsection A2. Count 2 of the indictment will be dismissed at the state's request. Is there any reason why a sentence should not be entered today, Mr. Harris? All right. Well, I know nothing about Mr. Maiden, and I know you're prepared to go forward. This isn't a presumption case, correct?
No.
Community control.
Presumption of community control, correct? All right. So are you gonna waive the PSI?
I will approve without it.
Typically, I either allow waiver of the PSI and ask for a sentencing memorandum because I would like to know as much as I can about Mr. Maiden so I can determine, one, if I place him on community control, for what term? The court doesn't like to be arbitrary in that. I don't want to place him on community control if I decide to do that for any longer period than necessary. So I need to know a little bit of background about him. But if you feel like you can do that sufficiently today, that's fine, Mr. Harris.
I think that I can, but we would have no objection to the PSI, but I think I can give the report of that background before we feel comfortable in deciding the appropriate number.
Yeah, let's see. I would really, like to get a PSI, because I have so much at my disposal, Mr. Megan, in terms of how long, if I were to place you on community control. And just coming in the right decision and not putting you for any longer than necessary, I'd like to know more information about you. So I'm gonna go ahead and order a pre-sentence investigation report, continue this matter 30 days for sentencing.
Does the report be available January 13, Your Honor?
Let's see, Ms. Hopkins is helping me with that today.
January 13th. At 9 a.m.
That's fine.
All right. Sentencing, January 13th, 9 a.m. All right, Mr. Megan, you must go to the probation department for a pre-sentence investigation. Now, during COVID, they've been doing things a little differently, so you might go and they might say, oh, here's the telephone number, call us, okay? Or they might interview you right then. I'm not sure how they're gonna do it. But in any event, you must cooperate fully with their investigation. Answer all their questions truthfully, no matter how painful it may be, because they'll give you a written report, all right? That helps me understand a little bit more about who you are in your background. And then on the sentencing date, I will allow the attorneys to see the report, and then we will go from there, okay? All right, and so I'm gonna ask you to report today over there right away, and then it shouldn't take but a few minutes, like 20 minutes at the most, okay? And then we'll see you back here on January 13th at 9 a.m.
Thank you.
All right, thank you. Oh, here's green forms. Hey, would you mind texting us Howard and see if he's a PSI numbers? I know they're somewhere close by. It's her desk lock.
I can go in, Your Honor. You know what I mean?
Yeah, I understand. John, it might be in that stack right there. This stack right here.
Here?
Yeah, I think they're green forms.
Yeah, the green forms. I need to go to another room again.
There's it, that's the, what you're holding is the index. So that you're holding. Mr.
You see the new day of Nigel Turner?
Yeah, Mr. Magnus, yeah.
I sent him to the body camera, he has not seen that yet, it's just his time to view it.
Okay. You waive your client's presence, Mr. Magnus?
Yes, Your Honor.
Okay.
Mr. Turner is here.
Oh, he is?
Yes.
Okay.
Oh,
he is here?
He is here,
Oh, okay. You don't waive his presence.
but I'm waiting time.
Oh, you're in time. All right, thank you.
Sorry,
All right.
With January 24th, we live in the court?
Probably, I'll ask Ms. copy of the January 24th report.
Yeah. There's a bunch of jury trials, I'm not sure if that's okay.
Oh, it's a Monday?
Yeah, maybe.
Yeah, it's okay.
Okay,
9 o'clock.
all right, yeah, that works.
All right, January 24th at 9?
Thank you, Your Honor.
All right, you're welcome. Did you wait time?
All
right, thank you.
By signing that agreement.
Thank you so much.
Yeah.
All right, Mr. Myers, you can bring your client in and sign entry?
I don't think I'm all inside.
Oh, you already have it?
I got the end.
Perfect, okay, thank you. Still got it?
Is Rodney still here?
Miss, Hawkins, this is the one. I used to bend the box, but she Thank you. Yes, sir.
Mr. Larson is here covering for Mr. Malat on Roach. And, he just Roach, just gave me a date on that.
Mr. Malone is not feeling well, Your Honor.
Okay.
He did advise me that he believes his client is interested in a plea on this.
Yes,
I don't know what
please.
the calendar looks like at this point.
All
I
right.
would feel uncomfortable doing the plea, not knowing the client.
Is he here today?
He's locked up.
Oh, it's not.
So
Okay.
that's why I'm asking about the calendar, to see if
Sure.
there's something extra that we might be able to accomplish.
You want to
Do you want me to do it? No, I don't know that.
All right, so Mr., these are pretty new cases.
Yes.
How much time do you think Mr. Malat will need?
As far as I can tell, it's just a head cold that he's got knocking out.
All right.
He took a COVID test, he does not have COVID.
Okay.
It is my understanding that Mr. Roach does want to enter a plea as soon as possible. I don't know if you have any dates coming up in the near future.
We're back on the 25th, the 13th, Your Honor.
2 days from today?
Brittany Hill is at the 13th, which is co-defendant.
Oh, January 13th.
13th.
Oh.
He said that day that works.
Yeah, he said he wants to do it pretty quickly.
Yeah, is there anything soon? I just feel uncomfortable because he is incarcerated.
I understand. Let's see.
And if need be, if Mr. Milano is still sick, I would go and talk with the individual and find everything out about him so that I can't what I can do with you.
Okay.
They're not following, right?
Yes.
We can do it on, Tuesday the 4th.
You did the fourth, you did the soonest date, that's it.
That's as soon as we have.
Let's do that then.
All right, January 4th. 9 a.m. You waive time on behalf of Mr. Roach.
I do, Your Honor.
Do I need to bring him down?
No, no.
All right.
My understanding that Mr. Milano is still in
All right, we have 2 entries for you to sign for us, and you waive his presence at this time.
Yes, Your Honor.
All right.
Thank you, Judge.
Thank you for covering.
Absolutely.
PSI, on John, Chandler, John. I'm John? Yeah.
My client's Rogers.
I put the work there, over there this one. If I did that wrong, I apologize.
I got you.
All right, who do you want to do next?
Thank you, Judge. Happy holiday.
Thank you, too.
Yeah, Chandler, John.
Cameron Johns.
Sidewalk.
Okay, we can do it. Let's have on that.
Thursday intervention, we
Yes.
the court's going to do that to have it worked out.
Okay,
I don't have any objection.
okay.
I have the free paper for the prayer, Your Honor.
All right, and we can add.
Yeah.
Up to 2 years. Good. I will need this completed. And you have seen the report?
Yeah.
Okay.
Yes, I'm right.
Mr. Gabbard is here, he is,
Dr. Rogers,
oh,
separate sentencing.
yeah. Okay. Perfect.
No. Yeah, but
All right, now you have my comes to podium. All right, this is a matter of State of Ohio versus Chandler Johns, case number B210-3273. Mr. Matthew Greenberg on behalf of Mr. Johns. Mr. Johns is present. Mr. Nick Croswell of the State of Ohio. We're here on the defense motion for treatment in lieu of conviction. And that motion was filed, looks like on October 25th, 2021. The court ordered a court clinic report, and I'll ask counsel, have you both seen it? All right, excellent. So it looks like Mr. Johns is charged with an eligible criminal offense as defined by revised code 2951.041D. Considering those conditions set forth in that code section, conditions 1 through 9, the court finds that the conditions are met and will grant the motion for treatment in lieu of conviction. Any objection by the state?
No objection.
All right. Are you the Chandler Johns named in this indictment?
Yes, ma'am.
How old are you?
22.
All right, 22. How far did you go in school, Mr. Johns?
I dropped out of the junior.
All right, did you ever obtain your GED?
No, ma'am.
All right, do you plan to?
Yes, I do actually.
All right. Are you able to read and write the English language well?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Have you ever served in the military?
No, ma'am.
All right. Mr. Johns, I have in my hand three forms here. The first is waiver of trial by jury. It's a single-page document. There are signatures at the bottom. I recognize your attorney's signature in this bar number here. Is this your signature here, sir, where it says defendant?
Yes, ma'am.
This is an acknowledgement by you that you understand you have a constitutional right to have a trial. But when you sign this form, are you okay right there, sir? All right. When you sign this form, you're acknowledging that you understand you have a constitutional right to have a trial, but you're giving up that right when you sign this form. Do you understand?
Yes, ma'am.
Is that your understanding of what you were doing when you signed this form?
Yes, ma'am.
All right. Did you sign this form after consulting your lawyer, Mr. Greenberg, about your constitutional right to a trial?
Yes, ma'am.
Do you have any questions about this form?
No, ma'am.
All right. Do you have any questions about your constitutional right to have a trial?
No, ma'am.
All right. Miss Hopkins, would you mind turning on the blinds now a little bit so that it can be your face? All right, I also have in my hand an entry withdrawing plea of not guilty and entering a plea of guilty. It's a 3-page document. On the third page, there are signatures. I recognize the prosecutor's signature here, your attorney's signature, and his bar number here. Is this your signature here, sir, or is this signature of the defendant?
Yes, ma'am.
All right. And then finally, I have a form entitled Defendant's Waiver of Speedy Trial. Is this your signature here, sir, signed today?
Yes, ma'am.
Did you sign this form after consulting your lawyer about it?
I did, ma'am.
All right, thank you very much. Mr. Prosecutor, would you please put the parties agreement on the record?
You're all going to change the plea from not guilty to guilty on count.
All right. Is that your understanding, counsel?
Yes, Your Honor, we have a new motion.
All right, is that your understanding, Mr. Johns?
Yes, ma'am.
Thank you. Sir, are you under the influence of any medications, drugs, or alcohol today?
No, ma'am.
Do you now, have you ever suffered with or been diagnosed with any type of mental difficulty?
Yes, I was bipolar and
depression, a few years back.
All right, were you prescribed medication to manage your conditions?
I was, yes.
Do you still take that medication?
No, I do not.
All right. Have you been released from your doctors about all your gallbladder?
Yes.
Okay, all right. As you stand here today, I know you may be a little nervous, but do you feel like you have clarity of mind and you know what you're doing?
Yes, ma'am.
All right, thank you. Are you presently under any type of probation or community control supervision?
Yes, ma'am.
All right, can you tell me about that?
Yes, ma'am. I am on felony probation for child endangering and.
That's here in Hamilton County,
Yes,
to me, right?
yes, ma'am.
All right. Anything else? In any other state?
No.
All right.
No, ma'am. I'm sorry.
Has anyone threatened, forced, or coerced you in any manner into entering into this plea of guilty today?
No, ma'am.
Has anyone promised you anything at all if you enter into this plea of guilty today?
No, ma'am.
Are you making this plea of your own free will?
Yes, ma'am.
All right. Mr. Johns, have you had an opportunity to read this 3-page or review this 3-page plea agreement form with your lawyer?
Yes, ma'am.
Do you understand what it says?
Yes, ma'am.
Do you have any questions?
No, ma'am.
All right. Do you feel like you've had enough time to consult with Mr. Greenberg about your case before this proceeding today?
Yes, ma'am.
Has he answered all of your questions to your satisfaction?
He has.
All right. Have you had an opportunity to review the discovery, the evidence the state has against you?
Yes, ma'am.
All right. Mr. Croswell, please put on the record whether the state has provided all discovery to your knowledge, including any Brady material in any?
We got it.
All right. Mr. Greenberg, do you acknowledge receipt of same?
There we go.
All right. Mr. Johns, are you satisfied with your lawyer, Mr. Greenberg?
Yes, ma'am.
Okay. Now, sir, do you understand the charge against you, which is aggravated possession of drugs of felony in the 5th degree?
Yes, ma'am.
Do you understand that if you plead guilty to this offense, you are making a complete admission that you committed the allegations contained in the indictment,
Yes, ma'am.
in that count of the indictment?
Yes, ma'am.
All right. This being a felony of the 5th degree, do you understand that you are facing up to a potential sentence of 12 months if found guilty, of course, to 12 months up to a maximum fine of $2,500? All right. Do you understand that if I send you to prison upon your release from prison, you could be on post-release control for up to 2 years? If you violate the conditions of post-release control, you could be returned to the institution for a total of up to 1/2 of your original sentence.
Yes, ma'am.
Are you on post-release control?
No.
All right. Do you understand that if you are convicted of a new felony offense while on post-release control, that in addition to being punished for the new felony offense, the sentencing court could add an additional consecutive 1-year prison term or whatever time remains in your post-release control time, or whichever is greater?
Yes, ma'am.
All right. Since this is a felony of the 5th degree, do you understand that community control is a possibility?
Yes, ma'am.
Do you understand that the court could place you on community control for up to 5 years instead of sending you to prison?
Yes, ma'am.
All right. Do you understand that if you are placed on a community control sentence, you'll have to abide by all probationary conditions as established by this court?
Yes, ma'am.
All right. And if you are placed on a community control sentence, you violate the conditions of community control, you'll be brought back before the court for a more restrictive sanction, which could include prison time, among other things, up to 12 months. I just noticed my nameplate is gone. Oh, no worries.
Next order.
Yeah, sorry, I just noticed that. Also, if I impose court costs and you fail to pay the court costs, I could order you to do community service instead of paying court costs. Do you understand? All right. Now, I do understand this is a motion in lieu of conviction, and so, but I do have to notify you of all the maximum penalties. You understand? And options. All right. When you plead guilty, you give up some very important constitutional rights. I need to make sure that you understand them. Do you understand you have a right to have a trial either to the court or to a jury of 12 persons? Do you understand that you have a right to confront witnesses here in open court and have them cross-examined by your lawyer? Do you understand that you have a right to have witnesses subpoenaed to come to court and testify on your behalf? Do you understand that at trial, the state of Ohio has the obligation to prove your guilt beyond a reasonable doubt? Do you understand that you cannot be forced to testify against yourself at trial? Do you understand each of these rights, Mr. Jones, as I have explained them? Do you have any questions whatsoever? All right. Do you understand that if you plead guilty, you are waiving all of these important constitutional rights? Knowing everything the court has discussed with you this morning, do you still wish to enter a guilty plea to count 1, aggravated possession of drugs, a felony of the 5th degree? All right, may I hear the facts?
625-21, county state defendant knowingly possessed illegal controlled substance, amphetamine. This, Your Honor, officers executed a search warrant. Defendant is not a resident of that address, just seemed he was just there. Found to have 18 arrow on the person.
All right. Is there anything further, counsel, before I accept the plea?
Nothing further.
All right. Mr. Johns, what is your plea to count 1, aggravated possession of drugs, a felony of the 1st degree, and of the 5th degree? All right. Well, the court is going to accept the plea, but I'm not going to make a finding of guilt. I am going to stay these proceedings at this time. An entry will be prepared by the court granting the motion and ordering you into intervention in lieu of conviction, under the supervision of the probation department, subject to the following terms. Number 1, the intervention plan will be for 1 year. 2, you shall abstain from the use of illegal drugs and alcohol. Number 3, you are to participate in treatment and recovery support services. Yes.
I'm in Brightview right now. Does that count as
That counts.
Okay, just stay in Brightview and keep doing good.
Keep doing good.
Okay.
You are to submit to regular, random drug and alcohol testing. I am going to order that you complete 5 hours of community service during that 1 year period. And you are to maintain employment.
Yes, ma'am.
And I would really like to see you get your GED.
Okay.
All right, so I'm gonna put that as not a mandate, but an encouragement. I want to see you get your GED.
Thank you, Your Honor.
Is there anything further from council?
I don't believe so.
We can take a report date, Your Honor.
A report date? All right. So that's the 1 year, right?
Yes.
Okay. So, Ms. Hopkins, can we find a report date 1 year from today? So sometime December 2022.
Are you okay with Wednesday?
December will be to count, yes, 2022.
Yeah, 9 a.m.
We're making that move, please, so typically we have an interview.
9:30.
Yeah, big plan.
So this is the 14th.
Stand
up.
Okay, so December 14th, 2022 at 9:30 a.m. All right. And so he'll have to report to probation.
Yes, sir.
All right, thank you very much.
Thank you,
All
Your Honor.
right, I wish you well.
Thank you. Really appreciate it.
Continue.
I think so. Mr. Greenberg, yes, let's go ahead and sign for the continuing state to 2022.
Oh, yes.
Okay, let's do that.
It was up in the air.
No, thank you so much, John, I appreciate it. Mr. Gabbard to come back and
He's
he's.
on
Oh. Yeah. He's been waiting. Yes. All right.
Yes, Steve's been around, that's who Mr. Moss are at all. Yeah, I know that's what I'm
Let's see, oh, it got moved. They did a motion to continue because he took it. So, yeah, that's her situation and, to get her children situated. It's January 3rd, first day, January 3rd at 9. That's Robertson, Tierra Robertson.
Is that,
It's not on our map because we already moved it.
oh, okay, I thought it was continuing for
Yeah, no. Okay, Mr. Winky, he needs to, Mr. Costa, Mr. Winky, are they not coming back?
They were in, now they're coming back, I think they were just waiting.
They're just filing a pre-trial, so, Mr. Croswell, on Kenneth Ty and Mark.
I sent Mr. Ricky by camera, he probably not to do it yet. So he went down with that.
Okay. All right, well, I'm wondering if you want to continue.
There it
is. Oh, here it is, yes, thank you.
Here.
Hi, Mr. Winky.
Hey, Judge.
I know you've been waiting quite some time.
That's no problem.
On, Mr. Ty, do you want to, we have a trial date, January 31st.
Yes.
And, this was set for a final pretrial conference. Do you just want to continue the final pretrial conference till we get closer?
I would love that.
Okay,
Because I have a couple of issues, and I think they'll be resolved shortly.
okay. Continue final pretrial conference. Ms. Hopkins, can we look at, let's see, January on this, or this is a final pre-trial conference. That's on Kenneth Ty.
It started out that way anyway, right?
It is adjourned.
Well, his trial date is 31st, so we want to have it like 2 weeks before.
I think that we could attend. The 11th looks good to me.
Yeah.
Well,
How about, January 10th at 9 AM?
Could we do the 11th? Is that all right or
Um,
not? I just don't want to keep it where we
yeah, January 11th at 9 AM.
Yes,
Okay.
that works better.
All right.
Thank you.
Well, January 11th, 2022, 9 AM, time waive, we have a trial date. Can we go ahead and get you to sign this with the.
He already did it.
Oh, he already has it, okay.
Thanks, Joanne, I appreciate it. You really good, 2022. Yeah, if you see that.
Was your client here, Mr. Winky?
Judge, he had a transportation problem this morning. I've been in contact with him.
All right, I'll, you're waiting his presence for today? All right, he'll be here on the 11th.
Yes.
Okay, thank you.
And I'll be in touch with him before then. You just get that in.
Okay, thank you.
Thank you. That's awesome. Appreciate it. See you later, everyone.
I believe that Mr. Austin is, and Mr. Gabbard are the only two left.
That's where I got your, I
And
mean, nothing to be wrong.
I think you're right. If that's it.
This is Mr. Jones.
Okay. Yeah.
I really not.
Yes, motion to, yeah. Yes, that,
So at least.
yes, that works. Thank you. They're doing
once a week.
Yeah, the two continuous ones we have left over, I'm just gonna shred. These are ones that are out.
Oh.
Yeah, they're just continuous ones.
But didn't we continue one to a PSI?
That one would get a form for.
Oh, okay,
These are ones that play, but
okay,
you have to forget it.
okay.
Give me the docket sheet when you're done.
Oh, absolutely.
Okay.
If you can read my handwriting.
I did send this one.
This is the one that you.
Oh, yeah, okay. All right.
It's like a rare style. Totally.
Here's the.
The victims are the witnesses are there. Yes. They get close, yeah.
I'll be back in 2 minutes.
Okay, thank you. I'm sorry, I just trying to read. Oh. If you need something?
No, all right, okay.
Okay.
You ready? Absolutely. You ready to ride here?
Please, just finished reading the submissions. You both had a chance to see the PSA.
Yes.
All right. All right, this is a matter of State of Ohio versus Robert Rogers, case number B 2005302. Mr. Rogers is present with his attorney, Mr. William Gallagher, and Mr. Nick Croswell of the State of Ohio. This matter is set for sentencing today. I don't know why my eyes have changed. Mr. Rogers had entered, no contest plea on November 18, 2021, to all 3 counts in the indictment. CCW, improper handling of a firearm in motor vehicle, and having weapons while under disability. The court accepted that plea, found him guilty, and ordered a pre-sentence investigation report. The court has received a copy of the report and has reviewed it. Mr. Gabbard, have you received a copy?
I have.
All right, Mr. Crosswell?
Yes.
All right. Mr. Gallagher, what would you like to say on behalf of Mr. Rogers? I want to acknowledge that I have received a letter from Miss Erica Rogers, Mr. Rogers' wife, and Mr. and Miss Williams, who are Mr. Rogers' parents, and I also received a certificate from Fortis College, Cincinnati Dean's List for Mr. Rogers, dated September 26, 2021. What would you like to say?
Just as you saw from probation, what they gave permission, they gave you biographical sort of list, is that he's married, with children, his wife is here in court, they offered that letter. They're relatively newly married. He has children that he supports without incident. For his certificate, his current employer is willing now to transition from maintenance into the HVAC work. Now that's what he got that certificate in, learning how to do HVAC work in buildings. So he's going from maintaining those in just a general sort of sense to now be responsible for the HVAC systems in those apartments that he's in charge of. That was the reason for seeking advancement. You know that he was arrested back in October without incident. He didn't cause any issue with the police. You heard the police testify at the motion to suppress hearing. You know that everything involved in this, what was seen in the body officer from the observations all the way through to the traffic stop. There was no aggression by him whatsoever. The guns found in the glove compartment after, at least the belief was, that it was carried around in the high crime area. He removed himself in the block party. There were no incidents. There was no interactions that caused any problem. And if you know that he's been on bond since October of 2020, now for 14 months without incident, without any new arrest. He stayed employed, he stayed in a stable home. And I would suggest to you some of those factors that should weigh heavily towards the idea of community control and his amenability to that. And we know that he has a prior conviction from the state of Georgia. He was placed on period of parole. He successfully completed that. Relocated back up here to where family is, and has always been since that. And you know, he's been doing productive things. I think that if you place him on a period of community control, you can be assured of what he's been doing for the last 14 months, which is to continue to work, support his family, come home, and take care of what needs to be taken care of. I understand there is no alcohol use issues. If you want him drug tested, that's fine. He's more than happy to comply with that. I don't think they're going to have any issue at all with that. They found that they believe to be a small scale in car. I know it tested negative. It's charged in this misdemeanor court. It's a room A. It's part of the parcel of this arrest, and so it's on a suspended docket. We're just sort of waiting for those cases to resolve. He's been a pleasure to represent. He and both his wife. Good humor, good natured, and I can tell you that the right amount of nervousness, not just today, but also even before all this. And I think that's a healthy sort of thing. He's not cocky about this at all. I'm quite nervous at that, about those future roles.
Thank you very much. Steve.
Your Honor, just to refresh, the firearm was in front of the glove box. It was loaded. There was a round in the chamber, and the safety was off. He was still occupying the car. He does have a little bit of a record, given that it is an old record. He has a robbery adjudication in '99, and then aggravated assault conviction out of Georgia in 2004. Really nothing since that last incident in Georgia. His last local contact in 2003 for a traffic violation. Nothing since then. I refer to the court.
All right, Mr. Rogers, is there anything you'd like to say?
Yes, ma'am. I would like to say this, Your Honor. It's no secret that I come from, the background of minority areas as Martin Hill and Appleton. I have friends and family there that I visit. It's no secret that I was once a knucklehead, Your Honor. And the thing about that is over these years, I have learned my lesson. I really have. That's why I changed my life. Your Honor, since my incarceration and me being present in parole, I successfully complete parole. No anger issues, even when I got pulled over to a matter that's beyond me. I never gave the police a hard time. I answered every question. I've been truthful. I've been in court. I paid my taxes. I paid child support. As you can see, I take care of my parents. I take care of my wife. I do the best thing. I try to be the best man that I can and lead by example. And also, I have a brother whose name is Daddy Rogers, who I've been living with it and he's a part of NCLU, and I've been needing to try to tell my story to kids to try to direct them from doing some of the things, some of the things that people have done or even I have done. I'm not a bad man, not a bad guy. I am nervous, as you can see, because this is serious. This is my life. My life has changed for the better, as you can see. I completed and graduated college. I made the dean list, which I didn't even know that I was making, but I was doing the best I can. I worked every job that you could think of, on down to a police pizza delivery guy, and now I'm a maintenance guy. And now I'm about to go into the HVAC world. So my whole life and career is changed. And if the courts would grant leniency on me to be able to continue to do so and take care of my wife and my family, me and my family and my wife, we will greatly appreciate it. And I promise that this court, that you'll see nothing but even more better things come from me.
Thank you, Mr. Ryder. Many people who look like you think that the system is only about punishment. But actually, the system is about justice. And justice includes punishment, rehabilitation, and fairness. And when you speak of how you used to be a knucklehead, being incarcerated in the past has, you've learned your lesson and you made strides to be a good and productive citizen. That's actually the goal. That's the goal. So I commend you on that. But I have to balance that with the fact that you're standing here again. Right?
Yes, ma'am.
And so the court never looks at people who stand there standing as a bad person. We judge the behavior. We judge the facts, not necessarily the person as a bad person. I believe you when you say you have a good heart, you're a good person. Obviously, you take care of your family. And I saw the videotape of your arrest. We had a motion to suppress, which I know you preserved your right for appeal. But I saw all of that. I saw how you handled yourself. And you did, you're right. You did handle yourself appropriately. You were cooperative. And for that, I commend you for that. Again, we have to balance the fact that you're here because of the charge, right? For which you've been convicted. You have made great strides in your life, and I hope that you continue on that path and continue to make great strides in your life. The court has considered the overriding purposes of felony sentencing pursuant to revised code 2929.11, which are to protect the public from future crime by this offender and others similarly minded, and to punish this offender using the minimum sanctions that the court determines accomplish these purposes without imposing an unnecessary burden on state or local government resources. I have considered the need for incapacitation, deterrence, rehabilitation, and restitution. I've reasonably calculated this sentence to achieve the two overriding purposes of felony sentencing and to be commensurate with and not demeaning to the seriousness of this offender's conduct and its impact on society, and to be consistent with sentences imposed for similar crimes committed by similar offenders. I've also considered the seriousness and recidivism factors as set forth in revised code 2929.12. Accordingly, I find that the presumption of prison is overcome. I sentence you to a term of 6 months community control on count 1. 6 months community control on count 2, and 18 months of community control on count 3. All counts to run concurrently with one another for a total term of 18 months of community control. I will tell you now that if you do all the things that you're supposed to do, I will consider terminating you. You will pay court costs, but the fines will be remitted. If you violate the terms of community control, the court has at its disposal a term of 1 to 5 years to sentence you to the Ohio Department of Corrections, and I will. Do you understand?
Yes, ma'am.
All right. Anything else, counsel?
Just, I think this is just I hate to say ordinary after working on for 3 years.
I'm sorry?
Well, plus the other 3 on the guns.
Okay, I just wanted to make sure, okay.
What,
I was concerned that you mentioned 5 years as a result of the F3. I'm concerned that is that F3 or F3?
Yes. Okay, cool. Yes, okay. All right. So, anything, counsel?
As the fire forfeit, Your Honor.
All right, is there agreement?
Just, the only thing I am going to let the court know is that I think he is still going to avail himself of his right to appeal this, so I'm not sure. I'm going to let the state know that they want to forfeit it in advance of this whole rest.
Let me ask this, is the,
I mean, I have no objection to it, but I was just saying.
okay, so wait, no objection? Okay, all right, that's, I either have an objection or I either have an.
I just wanted them to understand that before they get destroyed.
Oh, I see. All right, her agreement that firearm will be forfeited. Sir, you have a right to appeal your conviction and sentence. Should you choose to do so, you must do so within 30 days from today. If you cannot afford to process your appeal, an attorney will be appointed at no cost to you to help you. Do you understand?
Yes, ma'am.
I wish you well.
Thank you, ma'am.
Thank you so much.
What we do on this is
Hey, Ms. Hopkins, would you please call Bradley and tell him that he's on?
What did we do?
Oh, hold on, one moment, we're just gonna be.
I'm sorry.
That's all right. Okay, what do we do here?
Mr. Costin's case.
Who's that?
Roger. Mark Rogers.
Okay, I guess we're gonna have to continue Mark Rogers, because Mr. Costin's not here. That is set for, it was set for a final pretrial conference today.
When I talked to Mr. Monday, he was under the impression that they were both doing the same thing. They were both gonna continue it for their pretrial.
I guess, is this the same person? No, it's two, they're co-defendants, right?
Yeah.
They're co-defendants, okay.
I thought you meant Mr. Monday was a co-defendant.
But except he didn't file a motion to continue.
Yeah.
He needs to file a motion to continue, and I'll do that. So at this point, I have nothing to do, but,
I need to know that was, when talking to Mr. Monday, that was the, he talked to Mr. Johnson.
Let's go to the same
They
thing.
were both on the same page.
All right.
And if he had filed, then he might give him time to that, but that was there.
It's already set for January 3rd, we
Okay.
January 3rd.
Okay, thank you.
Yeah, all right, thank you.
guys might hear from probation.
Okay, just a moment.
I don't need to speak to the judge, just read about it.
Oh, okay.
It's a for this.
It's a favor.
If Mr. Costin wants to continue this, he'll have to file